Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here. And today we have our arraignment docket. The arraignment basically is an opportunity for the court to inform you as to what you've been charged with, what your rights are, and the options that you have regarding your case. Your case is a misdemeanor case. Criminal cases are divided either into misdemeanor or felony cases. And the case that you have, as I said earlier, is a misdemeanor case. The difference between misdemeanors and felonies is your felonies are your most serious type cases, like your aggravated sexual assaults, your murders, your burglaries of habitations of buildings, serious type drug offenses, and a host of other serious offenses. And with a felony case, your punishment can entail you being not only given a fine, but also being sent to the state penitentiary. Now, on the misdemeanor side, a misdemeanor case is normally referred to as a petty offense. That does not mean that it's not serious. It is serious as well. However, with the misdemeanor cases, we have Class A, Class B, and Class C misdemeanor. The Class C misdemeanor is the lowest misdemeanor. You get fined only. Now, for your Class A and your Class B misdemeanors, you can get a fine and you can be sentenced to the county jail. If you have a Class A misdemeanor, the range of punishment is confinement in the county jail for Class A misdemeanor up to 1 year, 365 days, or anywhere in between 0 days and 365 days. Or you could be given a fine from $0 to the maximum of $4,000, or anywhere in between. Or you could be given both such fine and confinement. For a Class B misdemeanor, the range of punishment is confinement in the county jail for a term not to exceed 180 days, which is 6 months. So it's 0 days to 6 months, or anywhere in between. Or you could be given a fine that does not exceed $2,000. So the fine could be from anywhere from $0 to $2,000, or anywhere in between. Or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called adjudicated probation, and the other type of probation is called unadjudicated probation. And the difference between the two is as follows. With the adjudicated probation, it does result in a conviction on your record as soon as you get on probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. Now, if you successfully complete the unadjudicated probation, which does not result in a conviction on your record, the case will be dismissed or will not result in a conviction on your record, and you may qualify for what we call a non-disclosure. A non-disclosure basically means that we cannot disclose the fact that you were on unadjudicated probation for your offense. However, if you violate the terms and conditions of your unadjudicated probation, the district attorney's office may file or can file a motion to revoke your unadjudicated probation. And that's a motion to kick you off the unadjudicated probation. If that happens, a warrant will be issued for your arrest. You'll be arrested, and then you'll be able to bond out of jail. You can have a hearing, and the hearing is just before the court or the judge. And then if it is proven that you have violated your probation, then the court can revoke your probation. And if your probation is revoked, your case is not going to be dismissed, and it may result in a conviction on your record. And therefore, you cannot qualify for a non-disclosure. Now, with the adjudicated probation, which does result in a conviction in your record, there's something that is called judicial, clemency. And what judicial clemency basically is where the judge or the court can set aside your conviction. And the way it works is as follows. You have to successfully complete the probation, which means they can, and that means it cannot have any more time on the probation. The probation has to expire. And then the court has to successfully discharge you off of the probation, let you off the probation. If those things happen, then the court can allow you to come back into court and you can withdraw your plea of either guilty or no contest. And then any complaint, affidavit, or information that has been filed against you will be dismissed. And if that happens, the court can set aside your conviction. You will no longer have a conviction. You can truthfully say that you were not convicted in this case. However, if you get a subsequent conviction, that means a conviction, another conviction later on for something else, then, or for another offense, then the court, if you apply for a license with CPS, that's Child Protective Services, then the court, they can deny giving you a license, or if you have a license, they could suspend or revoke that license. Now, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including a loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. The information that I just provided to you, that I just mentioned, we have some clipboards that have that information on it. And at the bottom of the documents, on the first page, it will have defendant's choice, mark initials next to only one choice. Now, if your choice is, I want to reset this case to hire my own attorney, then you will put your initials on the first line to the left. If your choice is, I have hired an attorney whose name is, then you'll put your initials on the second line to the left, and you will write the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. If your choice is, I have a court-appointed attorney whose name is, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will proceed to the bottom of that document where it says defendant, and you will sign your name. After you sign your name, then you will place today's date where it says date. Now, for those of you who are waiving your right to representation by an attorney and you want to represent yourself, you would have to fill out the next form. The next form is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this, and you put today's date, the 14th of April of 2021, by the county court at law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that's your choice, then you will sign where it says defendant, and you place today's date, April 14th of 2020, April 13th of 2021. And now you also have a right to have a trial by jury. And what that simply means that you have a right to have 6 citizens from Jefferson County to sit on your jury, to listen to all your evidence, and then at the conclusion of the case, they will decide whether or not you are guilty or innocent. Now, you also have a right to waive or give up that right to have a trial by jury. By waiving, it means you're giving up that right. And by doing so, you could either have a trial just before the court. We call that a bench trial. A trial before the judge is a bench trial. Or if you enter a plea of either guilty or no contest, and you can come before the court either with an agreed plea bargain agreement or an unagreed plea bargain agreement. The difference between the two is that agreed plea bargain agreement is that you and the state have reached an agreement to settle your case. And the other way is unagreed is you have not reached an agreement to settle your case, but you want the judge to decide what the punishment would be. You also have a right to have witnesses to come to court. And what witnesses do, they will testify in your case. They can testify for you or they can testify against you. You can ask them questions. We either call it direct examination or cross-examination. You also have a right to waive your right to have witnesses to come to it. In essence, you have a right to waive your right to call witnesses on your behalf. You also have a right to have what is called discovery. Discovery means you have a right to see the evidence that the state has against you in your case. And what that basically means is you have a right to see the evidence, if it's tapes, videotapes, witness statements, etc., on your case. Now, you also have a right to waive or give up that right, which means that you have a right to say, well, I don't want to see it. That's fine too. You can waive or give up your right to see the evidence that the state has against you. Now, you have an opportunity in your case, if you are representing yourself or if you're represented by an attorney, to enter a plea. You can enter one of 3 types of pleas. You can enter a plea of guilty, not guilty, or no contest. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or if you enter a plea of no contest, or what we call nolo contendere, you're telling the court that you will not be fighting or you will not be contesting the charges against you. If you are represented either by an attorney or you're representing yourself, your attorney or yourself would have an opportunity to talk to the state to see whether or not you can work out an agreement or a settlement on your case. We call that settlement or that agreement a plea bargain agreement. And if you are able to reach a plea bargain agreement, the court, the judge, that is, does not have to follow your plea bargain agreement. Now, if the judge doesn't follow your plea bargain agreement, you have a right to withdraw, which means you have a right to take your plea back. So if you come before the court, you say, well, I'm going to enter plea of guilty, no contest. The judge tell you, well, I'm not going to follow the plea bargain. Then you have a right to withdraw or take back your plea. Now, if the judge does follow the plea bargain agreement, and if you decide, say, within 30 days that you would like to appeal your case, what an appeal is, you want to have a higher court to look at it because you think you've been wrongfully convicted or error was committed, then you have to get the court's permission to appeal. Now, the appeal, if you're granted permission to appeal your case, the appeal will go to the Ninth Court of Appeals, which is right upstairs on the 3rd floor, right above us. They can either grant or deny your appeal. If they grant your appeal, they can find you not guilty, or they can send the case back down to this court or to this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than them. That higher court is called the Texas Court of Criminal Appeals. It's located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Now, pro se means you'll be doing it on your own without the assistance of a lawyer. You'll be representing yourself. And if they can either grant or deny your pro se petition, they grant your pro se petition, they can find you not guilty, or they can send the case back down to this court to order this court to give you a whole new trial. Or if they deny your pro se petition, then at that point, your conviction will stand. Now, everyone have been arrested on this case, on your case. And so you're out on bond. And every day that you spent in jail, those days could be used as credit toward your punishment. So for example, let's say the state has offered you 5 days in jail. You already spent 5 days in jail. You come before the court, then you can get credit for time served, which means that the time that you already served in jail has already been served. You don't have to serve any more time in jail. Now, if you have more time, if they offer you 7 days and you got 5, then that means you'd have to serve 2 days in jail. Now, every day that you spent in jail also counts as $100 per day that can be used towards your fine and court costs. And so what that means is if they're offering you a fine and court cost of $500, you spent 5 days in jail, that means that you don't have to pay anything because the time that you spent in jail has already paid it off. Your fine and court costs will be taxed and retired. That's what we call it. Now, the district attorney's office has a program that is called pretrial diversion. And what pretrial diversion is, it's a program designed for first-time offenders. That means you don't have a criminal history. Now, if you're able to get into the program, your case is dismissed and you could get it expunged from your record. What that means is an expunction means it can be wiped off, deleted, or erased from your record. How does the program work? First of all, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. You have to have an attorney to assist you with getting into the program, and you cannot have a criminal history. If you meet those qualifications, then you may qualify for pretrial diversion. And as I said earlier, you get into the program, the case is dismissed, you complete the program, you can get it expunged, which means erased, deleted, or wiped off from your criminal record. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has a program that is called Veterans Court. And for veterans, you can get into if you get into the program, complete the program, case dismissed, you can get it expunged from your record. Now, Jefferson County Court at Law Number 2, this court has a program that is called the Community Safety Initiative. It means it's, I usually refer to it as the CSI program, Community Safety Initiative. And it's a program that is designed to protect the community by addressing what we call recidivism. Recidivism means that people are committing crimes over and over. And so how do we address it? Well, we address it through partnerships that we have in the community with Spindletop, MHMR, and with Spindletop MHMR, which is one of the partners that we have, they have a mental health program, and a person can get an interview, an assessment, and a treatment plan, either outpatient or inpatient treatment. Also, they have a program that is called ATAR, stands for Addiction Treatment and Recovery. It's for individuals who may have issues with drugs and alcohol. And it's a youth program, 21 years or younger. And with that program, they can do an interview, they can do a screening, and they can develop a treatment plan, either outpatient, inpatient as well. Now, for individuals who are above the age of 21, there's a local agency called OZAR. OZAR, that's an agency where they can do screenings, treatment plans, and interviews for individuals who have drug and alcohol issues, either outpatient or inpatient services that they can assist you with the problem that you may have with drugs and alcohol. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. And what that simply means is it is a job training program and a job placement program. Individuals are trained in either the hotel industry, the shipping industry, or the chemical industry. Once they are given the training in those industries, then they will be assisted with getting a job in those areas, the area that they're trained in. And for individuals who have not finished high school, you need to get your GED. Well, Spindletop has a GED program, and CICE has a GED program as well. And so they can help you, assist you with getting your GED. Now, all of the programs that we just spoke of does not cost you anything. They are free. Only thing you have to do is have a desire to be in one of the programs. That's one of the benefits. The other benefit of the program is that all of these programs can be used as community service toward your punishment. So for example, let's say you were offered a fine and court costs. However, now you're offered a fine and court costs, you can't pay it today, we can put you on a payment plan. But let's say you can't pay it at all, you can't even pay it on a payment plan, then we can convert your fine and court costs to community service. And with community service, every hour that you perform on the community service, $12.50 will go toward your fine and court costs. So if you do 8 hours, that's $100 a day that will go toward your fine and court costs. Now, also, if with the fine and court costs, also I usually mention that you can kill 3 birds with 1 stone. What do I mean by that? Well, let me explain. First of all, you're ordered to pay a fine and court costs. That's 1 bird, but you can't pay it. And so we convert it to community service. All right. And that's the second one. And so the third thing is you're in one of the programs. Either you're in drug treatment, mental health treatment, you're getting a GED, you're doing job training and job placement. Any one of those programs that I spoke of earlier, that's free. That's the third thing. So while you're getting, let's say while you're working on your GED, or while you're in job training, you're sitting in class, being trained on a job, or you're in mental health treatment, or you're being treated for drugs and alcohol, right? You do an hour, that 1 hour will go toward, it's gonna be $12.50. It's gonna go toward community service, 1 hour, and then that 1 hour that you spent there will also be used as $12.50 that goes towards your fine and court costs. So you sit in class 8 hours, that's $100 that's going towards your fine and court costs, and 8 hours towards your community service. And you're being trained on a job, or you're getting mental health services, or you're getting drug and alcohol treatment, or you're getting your GED. And all of those things are free. Okay, so that's why we say that in county court law number 2, we don't have court as usual, we have unusual court. And it's not because we're different. It's because we're trying to make a difference in the lives of the individuals that comes before the court. And we're trying to make a difference in Jefferson County by making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And how we do that? By producing productive people. Why? Because productive people, for the most part, do not commit crimes. And if they do not commit crimes, the crime rate goes down. And we address the recidivism, and we are protecting the citizens of Jefferson County. So basically, that's our program that we have. If you're interested in the program, just let us know. We have some individuals who are here from Spindletop, and our mental health deputy, Deputy Hinton, is going to come forward, and he's going to mention to you some things about the mental health program that they have at Spindletop. So at this time, I present to you Deputy Hinton.
Thank you, Your Honor. Good morning. Again, my name is Steve Hinton, mental health deputy licensed by the state of Texas. I have 2 people that are here with me, my partners, Ms. Lisa and Ms. Shelby. They're both qualified mental health professionals from Spindletop, formerly known as MHMR here in Beaumont on South 8th Street. There's one reason why we're here, because the judge cares about each and every one of you. And what we found was some people who go in and out of the court system or in and out of the jail have underlying issues such as mental health issues or substance use disorders. So if we can address those issues, our goals, our objectives is to get you out of the system and get you in a productive life, whatever that looks like for you, whatever you want to have as part of your life. But there's only one problem, and that's going to be you're going to have to tell us. We don't know. We don't know that unless you tell us that. So we're here for you. We're going to advocate for you. We're going to walk you through the system. Sometimes walking through Spindletop can be cumbersome and a lot of red tape and stuff. We'll break that down for you. We will get you the need that you need, particularly to your situation, if this applies to you. Also, if you have maybe family members or something that are having mental health issues or substance use disorder, we'll be glad to talk to you about that as well and give you some resources and things like that so you can take that back to them and help them. Does anyone have any questions? Thank you. And I'll also, as the court proceeding continues, I'll be speaking to each and every one of you. If you want to have a private meeting with one of the qualified mental health professionals, you can in the back room. It's HIPAA regulated. No one's going to know anything about any information you divulge. And like the judge said earlier, everything today is free. It doesn't cost you anything. It just gives you options, opportunities, and resources about what you can do to better yourself if any of this that I've talked about applies. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Also, ladies and gentlemen, at this time, what we're going to do, we're going to have someone to pick up the paperwork that you have on the clipboards. Make sure that you fill it out, make your choices, and then once we get that paperwork from you, then we'll put you into one of the 3 categories, and then we will proceed from there. So at this time, the court is going to be in recess to give us an opportunity to